So, open fields. Open fields, the first case you read was the case of Oliver. And what's important about open fields is that if an area is deemed to be an open field, the police may search it without a warrant. So, it is not going to be considered a technical Fourth Amendment search because we have a principle that you do not have a reasonable expectation of privacy in an open field, even if that open field is a part of your property and something that you are demonstrating a desire to keep other people away from. Nonetheless, we as a society have deemed it's not reasonable to have an expectation of privacy in an open field. So, what happened here in Oliver? The police had a tip about marijuana, and the police did not have a warrant in advance. They went to the property. They did what is called here in this case a preview search, right? They looked around first before they got a warrant to see, do we see any marijuana here? And then they used the information they had gleaned from doing that preview search that they had no authorization to do. And then they went back and put that information in the warrant application. They used it to get a warrant. So the issue here is that the warrant is not valid if it is based on information that was gleaned through an illegal search. Like we have to go back before the warrant. Just because there's a warrant doesn't mean it's okay if they did an illegal search first. So let's look at what happened when they did that search, that preview search before getting the warrant. The police drove past a locked gate. There was a sign that said no trespassing. And there were people yelling at them, telling them, this is private. This is private property. That's the nature of the intrusion. Nonetheless, the area where they looked was deemed an open field. The court harkens back to language from a case of Hester, establishing that there is no reasonable expectation of privacy in an area that's an open field. So that's important for you to know. That is a hard and fast rule. If you are told this is an open field and then asked, is there a reasonable expectation of privacy in an open field? The answer is always no, there is not a reasonable expectation of privacy in an open field. The more tricky question is then addressed in Dunn, and that is determining, is it an open field or is it the curtilage? So here we again have drug offenses, but a much more serious and sophisticated drug selling operation. Bunch of chemicals that are used to produce basically a version of methamphetamine, and concerned that there is possession with intention to distribute. So like a massive drug making and selling operation with a more dangerous drug than marijuana. And the government here gets a warrant. So what's the issue? Same thing as the issue from the case of Oliver. They do some looking around and gather information before getting the warrant and then use that information in the warrant application. So the warrant itself would, again, not be valid if it's based on information gleaned in violation of the Fourth Amendment. So what did the police do before applying for a warrant? They got a warrant in Texas to attach to a beeper, which was a tracking device, to something that was used in the process of drug making, a drum of a chemical that is used to make methamphetamine. And they then attach the beeper to that chemical drum and trace the movement of the chemical drum. The chemical drum at some point signals back. The beeper indicates that the materials are on Mr. Dunn's ranch. And he has a really large ranch, like 100 acres. The police on November 5th make a warrantless entry onto the ranch. November 6th, they do the same thing. November 6th, after the second warrantless entry, they use what they've gleaned from those two entries onto the property and apply for a warrant. Then on November 8th, they search the ranch, they seize evidence, they get lots of evidence of drug making materials, and that is the basis for the charges. The court in Dunn analyzes 4 factors to determine whether or not the area where they looked on November 5th and 6th before getting the warrant is the curtilage or is it an open field? And in order to do that, they have to analyze if it's the curtilage or if it's the open field. So what's the curtilage? Curtilage is the area around your house that's associated with the intimate use of the house. It's not the house itself, which we know is sacrosanct under the Fourth Amendment, but you're doing stuff like right on your back porch and grilling and maybe in your outdoor pool that is associated with the house. It's private, it's intimate activities that you're engaged in. And there's a difference between doing those intimate activities in the area close to the house, the curtilage, versus an open field. So Dunn says we look at these 4 factors to determine whether or not an area is an open field and therefore entitled to no Fourth Amendment protection, or whether or not it's part of the curtilage and therefore entitled to the same Fourth Amendment protection that the house is entitled to. How close is it to the home? Is the area within an enclosure surrounding the home, right, like a fence? What's the nature of the use of this part of the property? Like I said, is there a pool, a hot tub? Is there something private that you're doing in this area? And are steps, number 4, taken to protect the area from observation by passersby, right, like a tall fence or something opaque? The court in Dunn does a really great job of analyzing the facts with these 4 factors. And I would suggest to you that you star this case in your notes and it's one that you come back to because it's an excellent example of analysis, of just applying facts to the law to come up with a decision. And what the court decides in the case of U.S. versus Dunn is that this area where the search was conducted was an open field. And an open field is not the curtilage and it's not the house. It is, just as the court set out in Oliver, picking up on the language of Hester, it is an area that is not entitled to Fourth Amendment protection, where the police may freely look around and it is not a search under the Fourth Amendment. So then what else is not a search under the Fourth Amendment? Aerial searches, so long as you're in lawful airspace. And that's a little bit nutty because lawful airspace is not determined by anything other than aviation rules about what's safe for airplanes to fly at. But the determination in California versus Serrallo, where there's an airplane that is flying 1,000 feet ahead, is that they're in lawful airspace. And so what the police are able to see looking down in Serrallo is plainly visible to them from that lawful airspace, then it's something that is being knowingly exposed to the public. Here's a quote from the case of Serrallo, and this comes from page 61 of your textbook. The Fourth Amendment protection of the home has never been extended to require law enforcement officers to shield their eyes passing by a home or on public thoroughfares, right? So that's the same thing that they're saying about what they're not required to do up in the air, right? They're not required to block their view when they are up in the air. They are observing something that, in the line of cats, is being knowingly exposed to the public, if it is something that can be seen from legal airspace. The next case in California versus Riley, we have a helicopter that's flying at a lower airspace. And in California versus Riley, it's only 400 feet. And the court makes a lot of comment about how this is lawful airspace, and that really is the legal standard. And this is the part that's a little bit tricky, right? Because the Federal Aviation Association was not, the FAA regulations were not devised with the Fourth Amendment in mind. They were devised with safety. Where is it safe for airplanes to be? There were 5 votes here for no search as a result. but no majority on the reasoning. So Riley was a little bit more complicated. Um, and one other note then about California versus Serralo. This involved a barn, and this case people often remember because there was a barn and it was covered, but then there was just this one part of the barn that was, even though it was covered and had a roof, where it was like something was coming off, and so that was the area where the police could see through from the lawful airspace. Um, and because parts of the top of that barn or greenhouse were open and were partly visible, that was um, then considered to be fair game. Even though the part of the property they were looking at was really um, enclosed within the curtilage, it was still nonetheless exposed because you could see it from lawful airspace, and um, it was partially covered and partially open for the greenhouse. Next, we're going to get to some other cases involving technology. Knott's, similar to the case of Dunn, has a beeper that is being placed on a drum of drug making chemicals and is traced, right? So he is again accused of drug manufacturing, um, drug possession with the intention to distribute. This beeper is placed on a drum and used to track the chemicals to a particular location. And the court here talks about how it's tracking the drum through what is just enhanced technology to be able to track what you could already see with the naked eye, right? Like the police could just be following the drum of chemicals from one place to another. And instead of the police just following the drum of chemicals from one place to another, the police um, are using the beeper to enhance their visual ability to see what's going on. So it is still considered public behavior that they're observing because it's on the public thoroughfares. Um, and the beeper then told the police where the chemicals were going and to whom they were going, and then that allowed the police to have more ammunition to get a warrant and do a search. So here, I would say that the takeaway is that the principle of what you knowingly expose to the public, your movements in a public thoroughfare, none of those things are private, and they're not protected by the Fourth Amendment. There's a tiny blurb in your casebook at page 84 about a case called Caro. Very similar to Knott's 1 year later. There's a beeper yet again, but the difference in this case is that in Caro, the beeper traces the chemicals in the public thoroughfare, right? Enhancing the police's ability to see what they can see with their naked eye. And then when it gets behind the threshold of the home, it's still communicating back. And so the problem there is that it was communicating things that could not be visually verified and communicating things from within the protection of the home. And that was a problem. It wasn't a problem to communicate what it saw from a public perspective. It was a problem once it went beyond the threshold of the home. And next, we have the case of Kylo. So Kylo is in 2001, and our technology is getting a little bit more sophisticated. This was by no means a simple case for the court to resolve. The Supreme Court was 5-4, and lower courts wrestled with this issue as well. It's really a very fact-specific analysis. Here, the police think that Kylo may be growing drugs inside of his home, and in order to grow the drugs in his home, he would need an awful lot of heat. So much heat, so much energy, so much light that it would just be outlandish compared to the energy uses of other homes. So here, the police are, while they are in the street out in front of Kylo's home and not inside the home, the question is whether or not they are invading the home and the privacy of the home and the intimate activities of the home by testing the thermal energy. And the court looks to say, um, is this technology something that's readily available, a thermal imaging device? Is this something that is easy enough for people to do? So you might argue it's not a search because the police are um, still in a public space when they are observing it, and they are enhancing the ability to do what they do with their naked eye. They're not actually invading the home. You might argue it is a search because they are invading the intimate activities of the home, things that are private. It could be that there is a sauna or that there is a hot tub, and those are things that are producing an awful lot of energy, and those are things that are private, intimate activities of the home that is nobody else's business, and that the police shouldn't have access to by testing thermal energy. And that's ultimately what the court decided, right? That it's relating back intimate activities from the home, even if the search is being conducted from the street. The difference is if you were walking by the house and you were like, whoa, heat wave, that's crazy. What the hell are they doing there? I feel how hot it is. That would be lawful. But if you're walking down the street and you can't tell anything different about this home and you have to use a thermal imaging device to test what's inside the home, then that is just going to be taking it a step too far for Kylo. That is a Fourth Amendment search, and you would need a warrant to do a thermal imaging test. All right, this may seem a little bit antiquated to you when you read it. Smith versus Maryland. Uh, the issue here is, was there probable cause for the warrant? And the warrant was used to get telephone numbers from what is called a pen register. A pen register is just a list of telephone numbers that someone has called. So this is back in the day before we had cell phones, but it is equivalent to if you got an actual written cell phone bill, looking at just the list of phone numbers that you've called, the list of phone numbers you've had a text message with, without actually knowing what the contents of those conversations were or the contents of those text messages were. The court here says that it is not a search because there is no reasonable expectation of privacy in the phone numbers that are dialed. And a pen register only reveals those numbers and not the conversation. I don't know about you, but I certainly have made a phone call or two in my life that I would just be embarrassed if other people knew I made. And I would have an expectation of privacy that is subjective at the very least in what those phone calls have been. Unfortunately, I have no reasonable expectation of privacy. Now you know. Smith applies to email, something that perhaps is a little bit more accessible to a scenario we might imagine ourselves in our modern society. Email addresses would be something that the police could get, although not the contents of an email, right? Not the actual conversation, what was exchanged, but a list of all of the addresses that are in your email. Um, that would be something that would be the equivalent of on a pen register, the list of the telephone numbers that were called. So we are nearing the end of this recorded session. I want to preview what you will be dealing with in the live session. We will discuss the next generation of public information cases, right? When public information is conveyed to a third party and eavesdropping, by continuing talking about what happened in Katz and applying it in the case of White. White is a very little blurb, but we'll talk about it more in class. It's on page 84 of your casebook. We're also going to talk about the case of California versus Greenwood, which involves searching one's trash, something that I'm sure we all want to have an opportunity to discuss and know more about. And then we will discuss the alternative theory of a search that was established by the case of Jones. Talk about the complicated situation that had been presented to the court in Jones and why Scalia resurrected this trespass theory to establish a new and different test for search that is an alternative test to Katz. We'll talk about how that test from Jones was further defined in the cases of Jardines and Harris. And we will talk about dog sniff cases. Cabales, Jardines, Harris are all cases involving dog sniffs, and Jones and Riley are cases that involve high tech. Jones involving GPS, where Riley involves something that's, again, I imagine super common for all of us to be wondering about, our own individual cell phones. When may the police search those, and do they need a warrant? And I also want to just note, because as we continue on in our study, this is something we're going to see over and over again. The phenomenon of police getting information that comes from a tip. Tips are information that's provided by a confidential informant. They call the police, they say, here's this person. I think Mr. Katz is gambling. I think Mr. Greenwood's dealing drugs, and Dunn has drugs, and Oliver has drugs, and Sorello has drugs, and Kylo has drugs. Everybody's got drugs. Um, there's a difference between when we have an individual who is calling the police and contacting them anonymously and won't say, hey, here's my identity, here's who I am, versus when we have someone who is a witness who calls and says, hi, my name is Samantha Buckingham, here's my phone number, and here's how you can reach me, here's what I observed, here's what I think, and then that person can be followed back up on. Right? There's a difference in terms of the reliability. So just pay attention to that as you're reading and think about that, because that'll be a topic that we address as we continue on in our study of the Fourth Amendment when we get to defining probable cause in the case of Gates. Thank you guys, and I will see you live very soon.